एनसीपी को लेकर शरद पवार और अजित पवार गुट आमने सामने हैं। महाराष्ट्र विधानसभा के स्पीकर राहुल नार्वेकर का एनसीपी को लेकर फैसला आने वाला है। नार्वेकर अब से थोड़ी देर बाद एनसीपी विधायकों की अयोग्यता मामले पर फैसला सुनाएंगे। दरअसल शरद पवार गुट ने पिछले साल जुलाई को एनसीपी में बगावत करने वाले अजित पवार गुट के विधायकों को अयोग्य ठहराने की मांग की थी। वहीं अजित पवार गुट ने भी शरद पवार गुट के विधायकों को अयोग्य करार देने के लिए स्पीकर से अपील की। हाल ही में शरद गुट को चुनाव आयोग से झटका लगा, जब चुनाव आयोग ने 6 फरवरी को उनके भतीजे अजित पवार को असली एनसीपी करार दिया। इसके साथ ही आयोग ने अजित पवार के नेतृत्व वाले गुट को चुनाव चिन्ह घड़ी भी आवंटित कर दिया था। ऐसे में अब देखना होगा कि स्पीकर के फैसले से किसे राहत मिलती है और किसे झटका मिलता है, क्योंकि अब यह लड़ाई विधानसभा के पटल पर पहुंची है, जहां विधायकों पर अयोग्यता की तलवार लटकी हुई है। हमारे सहयोगी राजेश इस वक्त मुंबई से हमारे साथ जुड़ गए हैं। राजेश, क्या संभावना नजर आ रही है जिस तरीके से शिवसेना के 2 गुट विधानसभा में क्या चल रहा है? सबसे पहले आपको वो सुनवाते हैं।
And 19 other MLAs of the Ajit Pawar faction. Petition number 4 is filed by the Sharad Pawar faction through Shri Jitendra Award against Shri Chetan Tupe and 11 other MLAs of the Ajit Pawar faction. Petition number 5 is filed by the Ajit Pawar faction through Shri Anil Patil against Shri Anil Deshmukh and 7 other MLAs of the Sharad Pawar faction. There are in total 3 petitions filed by the Sharad Pawar faction against the Ajit Pawar faction and 2 petitions filed by the Ajit Pawar faction against the Sharad Pawar faction. Filed by Shri Ajit Pawar faction against Shri Sharad Pawar faction by order dated 16 January 2024, I had by consent of both the parties consolidated all the petitions into 2 groups. Petition number 1, 3 and 4 filed by the Sharad Pawar faction were grouped as Group 1, and petition number 2 and 5 filed by the Ajit Pawar faction were grouped as Group 2. I would be pronouncing 2 separate judgments in these 2 groups. In the facts and circumstances of the matter and in view of the facts that the rival factions had emerged within the NCP prior to the initiation of disqualification petitions, I had to determine which faction was the real political party for the purpose of these disqualification petitions as per the law laid down by the Honorable Supreme Court in Subhash Desai matter. This issue is common in both the groups. So what I shall proceed to do is, I shall first pronounce the order in Group 1, where I shall first deal with the preliminary issue and then deal with the issue with regards to disqualification. And then we'll follow with the second petition, group. So, the Honorable Supreme Court in Subhash Desai versus Governor of Maharashtra, hereinafter referred to as Subhash Desai, was pleased to hold that the Speaker should prima facie determine who the real political party is for the purpose of adjudicating disqualification petitions, if 2 or more factions claim to be that political party, in keeping with the principles discussed in the said judgment. A bare perusal of the pleadings in the present matter indicate the emergence of 2 factions within the NCP, the Ajit Pawar faction and the Sharad Pawar faction. Although the said judgment was in the matter that arose from a somewhat similar political situation that arose in the House concerning the Shiv Sena, it does constitute a precedent that would apply on all 4 of the petition's present disqualification matters as well. Hence, keeping in view the similar factual matrix and the law laid down by the Honorable Supreme Court in Subhash Desai Supra, I will prima facie determine which faction is the real political party for the purpose of adjudicating these disqualification petitions. The said preliminary determination is necessary before examining the merits and deciding whether respondents have incurred disqualification under the 10th schedule of the Constitution of India. Therefore, to quote, the preliminary issue that arises for my consideration before delving into the merits of disqualification petition under the 10th schedule is which among the two factions was the real NCP political party for the purpose of deciding the present disqualification petitions. The other issue framed for my consideration in this group of disqualification petitions is whether the respondents have incurred disqualification in terms of paragraph 2(1)(a) of the 10th schedule of the Constitution of India on account of their alleged acts, omissions and/or conduct. So we'll go to the analysis, observations and the findings with regards to which amongst the two factions is the real NCP political party for the purpose of deciding the present disqualification petition. In view of the fact that in the present matter rival factions have emerged and both the factions claim to be the real political party, read with the law laid down by the Honorable Supreme Court in Subhash Desai Supra, stipulating that this forum should prima facie determine who the political party is for the purposes of adjudicating disqualification petitions. If two or more factions claim to be that political party, it is necessary to consider and determine the preliminary issue before examining the merits of these disqualification petitions. Principles laid down by the Honorable Supreme Court in Subhash Desai relevant for the purpose of determining who the political party is. I am not reading out all the contents of the Subhash Desai which we have referred to and relied upon. I will straight away go to my observations. Thus, what emerges from the principles laid down by the Honorable Apex Court is that the question of who the real political party is has to be considered and determined after giving due weightage to 1. The constitution of the political party, 2. The leadership structure of the party, and 3. The legislative majority if two or more factions claim to be the real political party. The question as to who the real political party is hereinafter referred to as the preliminary issue. Since in these proceedings both the factions are claiming to be the real political party at the relevant point of time, and as the said issue arose for determination in these proceedings on 16 January 2024, the said preliminary issue was also framed as one of the issues in these disqualification petitions, thereby affording an opportunity to the parties to make their submissions on this point. I proceed to consider and adjudicate on this. I would be adjudicating the said preliminary issue based on 1. The principles laid down by the Honorable Apex Court, 2. Record available with the Maharashtra Legislature Secretariat, and 3. Submissions made and documents referred to by the parties during the course of the hearing in these disqualification petitions. Petitioner's submissions on the preliminary issue, I am not going to go into reading those submissions again. They are a part of my order which you can refer to. There are also observations with regards to the respondent submissions on the preliminary issue, which also are there in my order, which I wouldn't be reading out at this point of time. Analysis, observations and conclusions on the preliminary issue. As recorded earlier, the decision of the preliminary issue has to be taken after careful analysis of 1. The constitution of the NCP, 2. The leadership structure of NCP, and 3. The legislative majority. After having heard both the sides on the above aspects, I now propose to proceed to record my observations and findings on the preliminary issue. In the present matter, there is no dispute as to the relevant NCP constitution. Both the parties have placed reliance on the constitution and rules annexed as Annexure R1 and R2 to the reply filed by the respondents. The said constitution of the NCP and rules are hereinafter referred to as the NCP constitution and NCP rules. On 30th June 2023, a resolution was passed by 41 legislators of the NCP electing Shri Ajit Pawar as the president of NCP. A dispute under paragraph 15 of the symbol order was also preferred by the Ajit Pawar faction before the Election Commission of India. Sharadpawar faction objected to the resolution dated 30th June 2023 and executed affidavits in support of the leadership of Shri Sharadpawar, which were filed before the Election Commission of India. Thus, it is abundantly clear that two rival factions had emerged in the NCP on 30th June 2023 itself. Hence, the relevant date on which two factions emerged in NCP is 30th June 2023. As recorded earlier, there is no dispute about the relevant constitution of the party. Thus, the said NCP constitution is taken into account for identifying the leadership structure of the NCP. Since there is no factual consensus on what or who constitutes the relevant leadership structure which has to be taken into consideration, it is necessary to peruse the NCP constitution so as to identify the leadership structure provided for in the constitution and consequently examine the leadership structure put forth by both the sides. Article 5 of the NCP constitution, read with NCP rules, provides for a vertical organizational structure which consists of unit committee, city division committee, area committee, town committee, panchayat committee, constituency committee, district committee, regional committee, union territory committee, state committee, working committee and national committee. Each committee at the bottom level acts as the feeder cadre for electing the next immediate higher committee. Article 12 of the NCP constitution provides that the state committee shall consist of delegates elected from the constituency block committee. Further, NCP constitution provides that all members of the state committee shall be delegates entitled to vote in the election of the president. National committee of the NCP consists of 1/10 of delegates, the president, the ex-president of the party who have completed a term of 365 days and continue to be an active.
इस पर इस वक्त महाराष्ट्र के विधानसभा के अध्यक्ष जो हैं वो अपना फैसला पढ़ रहे हैं। महाराष्ट्र का बड़ा फैसला आने वाला है जिसमें एनसीपी के विधायकों की अयोग्यता पर उनको निर्णय देना है। राहुल नार्वेकर अपना फैसला पढ़ रहे हैं, लेकिन इससे पहले आप देख चुके हैं शिवसेना के ऐसे बिल्कुल समान से मामले में जो उनका फैसला था वो शिंदे गुट के पक्ष में गया था। तो ऐसे में आज इस बात की संभावना सबसे ज्यादा है कि आज का फैसला अजीत पवार गुट के पक्ष में जा सकता है। हालांकि वो अपना फैसला अभी पढ़ रहे हैं, थोड़ी देर में ये स्पष्ट हो जाएगा। आज की दूसरी बड़ी खबर आपको बता दें, सरकार और आंदोलनकारी किसानों के बीच बातचीत शुरू होने वाली है। थोड़ी देर में किसान नेताओं और सरकार के बीच बातचीत होगी। केंद्रीय मंत्री एक तरफ होंगे और दूसरी तरफ होंगे किसान नेता। किसानों की तरफ से सरवन सिंह पंढेर और जगजीत सिंह डल्लेवाल ये वार्ता में शामिल हैं और सरकार की तरफ से 3 केंद्रीय मंत्री वो इस वार्ता में शामिल होंगे। अर्जुन मुंडा, पीयूष गोयल और नित्यानंद राय। 2 दौर की बातचीत पहले हो चुकी है और अब तीसरे दौर की बातचीत आज होने जा रही है।